seated, thank you.
Ready, Mr. Escobar?
Thank you, Your Honor.
All right, go ahead.
Vernon Adams. Why did we bring Mr. Adams, Dr. Adams, before this court? Human beings don't really want to know how vulnerable we are. How vulnerable is our skeletal system? How vulnerable is our head? I think Dr. Adams was able to explain to you how our skeletal system, our head, how a punch to the head could cause great bodily harm and or death. One punch. I just finished myself in my office defending a one-punch homicide. The head is the most vulnerable portion of our body. Dr. Adams explained to you the anatomy of making a fist. And what happens when we wrap that finger in that position? And we strike someone with enough force to break orbital bones, break your jaw, break your temporal bones, to break your nose, and to cause, at the very least, great bodily harm. But was it Dr. Adams alone that educated us on that? No. Crime scene detective Aaron Smith did as well. And so no, you don't have to have a phone in order to be in reasonable fear of great bodily harm. It is just as reasonable, if you listen to Detective Smith, it is just as reasonable to be fearful of that fist that is made at the time of the attack. Now, along with what Dr. Adams educated us on, we have to incorporate the testimony of Michael Knox. And Michael Knox talked to you about a very important phenomenon that happens in these deadly force encounters called perception distortion. One of the reasons that I asked Detective Smith as well was because I knew Detective Smith had gone to the training every year to talk about perception distortion. And that's what happens to police officers when they're out there in the streets and they get encountered by someone that's about to commit some dangerous act upon them. And they're trained to try to fight against that perceptual distortion, and as Detective Smith talked about, tunnel vision. Remember he said, yep, I know about tunnel vision. We try. Are you successful? No, it's very difficult because you're trained to focus on that threat. And many times what happens is that fear, that anxiety takes over, and you're focusing strictly in that tunnel vision fashion on that threat. Now, do we really think that by any stretch of anybody's imagination here, that when Mr. Olson came over at Mr. Reeves, over the chair, do we think that anybody could have perceived that he was going to get a bag of popcorn? Mr. Reeves has already been hit in the head, we believe by a phone. Now Mr. Olson is coming that second time at Mr. Reeves. That decision to use deadly force, look at the timestamps. Look at the perception reaction times that Michael Knox spoke to us about. That decision to use deadly force was made way before that popcorn ever got in the hands of Mr. Olson. And how do we know that? We know that because in the interview of Curtis Reeves, he had no idea what had happened to that popcorn. It was that perception distortion, it was that tunnel vision that consumes us at a time when we're making critical decisions in a split second to use that deadly force that will save our lives. So those of us that are up here in this camera 11 and camera 12 again cannot envision the perception that is taking place from seat number 9 in that darkened theater with the previews blaring and the 71-year-old man fearing for his life. You know, in my discussions, it's kind of ironic that here in court today we're discussing what is Mr. Reeves' perception. Was his perception reasonable that he was in fear of great bodily harm or death? Have we for a moment considered what should have been reasonable in the mind of Chad Olson when his 43-year-old, 6'4" body was attacking a 71-year-old man? Have we even thought to cross our mind, should Mr. Olson have perceived that attacking a 71-year-old man could put this person in fear of death or great bodily harm? Isn't that a fair analysis? Isn't that a fair analysis for every human being in this country? Before they take an action against an elderly person, to understand that that elderly person is going to be extremely fearful over the disparity in age, the circumstances in which the attack takes place, and the perception of that person in a darkened theater with a previews playing. So let's look at it both ways, not just Mr. Reeves' perception, but Mr. Olson's perception as well, and what that should have been under the circumstances. Dr. Hayden said it best. Curtis Reeves, on January the 13th of 2014, was a trapped man. Dr. Hayden told you in this analysis, we cannot, and I repeat, we cannot take the testimony of those that have been contaminated in a scene like this Dr. Hayden, who for 7 years sat on a review board that did this very, very same thing. Dr. Hayden, a highly qualified expert that was not impeached, was not contradicted, but left alone to make that very important opinion. That in his opinion, Mr. Reeves was acting reasonably at the time that he had to fire that fatal shot. Because Dr. Hayden sat in the shoes of Mr. Reeves in making that opinion. He didn't sit in his own shoes. He didn't sit in the shoes of some young police officer that didn't have the experience that this gentleman had. He sat in Mr. Reeves' shoes and came before this court and swore to tell the truth and nothing but the truth, and said, "So help me God, my opinion is that Curtis Reeves was reasonable in his perception of imminent death or great bodily harm." And that testimony, Your Honor, was totally unrefuted. I'm going to close. I'm not going to go over the law because we'll be here for another 3 hours, and you've seen the memo that we've given to the court. This is it. And I know you've had an opportunity to read it, and I'm sure you'll read it again. However, a person is justified in the use of deadly force and does not have to retreat if he or she reasonably believes that such force is necessary to prevent the imminent death or great bodily harm to himself or herself or another, or to prevent the imminent commission of a forcible felony. I'm going to leave you with a thought. For this court to judge for itself. This is the booking photo. They didn't touch this with a 10-foot pole. The prosecution did. You didn't see them giving this to Dr. Throckmorton. And Doc, can you tell me, does that left eye there look a little swollen? They wouldn't get near Dr. Throckmorton with that, although Dr. Throckmorton seemed to be very gratuitous in his testimony for the prosecution. I'd like to publish to the court at this time. This is not a picture taken by Escobar and Associates. This is a picture taken by the Pasco County Sheriff, where it is clear to me, as it was clear to Mr. Reeves. Of course, it's not a black eye, it's not a busted, eyebrow, but clearly you can see even the distinction of the eyebrows and the puffiness. Now, was there anybody there to be able to take care of this for Curtis Reeves, to summons a doctor to forensically try to determine whether that was in fact part of the aftermath of the thrown phone? But Your Honor, the beauty of this scenario is that whether that light emanating or reflective is the phone, or whether that light emanating or reflecting Mr. Reeves crossing his legs, the beauty of that first recorded file the first recorded video file that shows Mr. Olson in Mr. Reeves' space, and the activity that takes place thereafter is that emanating or reflective light immediately moving. So was it moving because Curtis had been hit in the head and his leg came down? Or is it that phone that we see possibly going in the air, hitting Mr. Reeves and going down to the floor? Either way, it doesn't matter. Either way, it supports the defense position that Curtis Reeves was struck in the head with this phone. I ask the court today to review all the evidence and to find that Curtis Reeves was more than reasonable in his perceptions on January the 13th of 2014. That he was more than reasonable in his perceptions, having 27 years of knowledge in the use of force and self-defense, and having 12 years of knowledge in the security business for one of the largest corporations dealing with amusement parks in this particular area. For never having to fire his weapon and realizing that 27 years plus 12 shows a man with great restraint, and a man that on January the 13th of 2014 was doing nothing but trying to preserve his life. I thank you for your attention, Your Honor. I know it's been long. Thank you.
Thank you, Mr. Escobar. You ready?
No, no. Chris needs to come and help me get my TV hooked up, my computer hooked up. So
Okay.
do we have 15 minutes? I'll get everything hooked up and we can go straight forward.
Okay, that'll be fine.
Thank you, ma'am.
Thanks.
All right.